page with the headline. The headline is Accessible Law Through Language. And she's a Delta qualified English language teacher. And also she tries on removing the language barriers to advance people, productivity, and performance in a data-driven way. Did I do the introductions correctly, Niamh?
Perfect. One thing, my name, yes. So my name actually is not an English name; it's an Irish name. So I'm based in Ireland. So my name is Niamh, even though there's an M in there. So that's always confusing. And also then the company name is Tigim, which is also
Excellent.
It's also an Irish word, and it's a phrase. It means I understand.
Excellent. I understand. I've been on a huge Ludwig Wittgenstein trip lately, and as he famously said, like words are like tools. And if you think of all the tools in a toolbox, there might be a hammer, a saw, maybe a screwdriver. I don't know what you keep in your toolbox, but there's maybe nails and screws and whatnot. And the function of the words are as diverse as the function of these objects in the toolbox. So words really matter. And I seriously think that sometimes legal professionals lack these tools. We don't have everything in our toolbox. So I'm super interested in learning about those tools that we can use in our everyday legal design work to make law a little bit more accessible, a little bit more maybe even fun. So with that introduction, please, the virtual stage is yours, Niamh.
Thanks so much. Thanks for inviting me as well. And so I like your introduction. Making the law fun is probably a big mission, but one that I have no doubt can be achieved. So I'll just you can see my screen.
Yes.
Okay. So thanks for introduction. And my background is in English language, and it's also in science as well. So what I try to do is bring a data-driven approach and an awareness to organizations in sectors that we kind of call complex language sectors. So the law is definitely one where we find a lot of complexity in language. And so again, we're trying to do this in a data-driven way to raise awareness and make it more accessible. So what I'm going to speak about today is accessible language and the law. So looking at 4 different key areas. What is it? Why should I care about it? We'll look at some examples to see it in action. And then also, what strategies can I use? And that's strategies that you could use without even using technology as well, things that you could just use by yourself. So really the first thing is, it's very much known. Everyone must live by the rules of the law. It doesn't matter where you are, that the law governs every single thing that we do, whether it's in technology, how we live our lives, how we rent houses, buy houses, anything. We are governed by the law and we must live by it. So my question is, if it's for everyone, why can't everyone understand it? Why isn't it written in a way that everyone can understand? Because we have to live by it, so let's understand it. A lot of you on the call, I've already mentioned, English isn't your first language. It could be your 4th language. When we look at people, when we see people, we don't know their abilities. We tend to think of different abilities or disabilities in terms of physical things that we can see. And I don't like to use the term disability. I like to call it different abilities, different literacy levels. People that have dropped out of school, people that maybe have dyslexia, they have ADHD, people that English isn't their first language. And if you've ever been in a situation where you've moved country or you've been in a group of people where they're speaking a language that is not your first language, you perhaps have felt that you can't understand or you can't engage in that conversation. And that's exactly what happens when we look at things that have complexity in them. So when we're using, words, phrases, jargon, the more jargon that we use, the more we're creating a barrier to people that have different levels of abilities that we can't physically see. It's not only the words, it's not only legal terms, but it's really the combination of the words, phrases, as well as the structures that you're using. So you just mentioned there the tools in your toolbox. So words are one. but it's also how you combine those words together and how you present the information. The way you put them together can put a lot of burden or stress on people's processing, on their cognitive load, on the brain power. How much effort does somebody have to put in order to understand what you're trying to say? And that's really something that we try to focus on. And what we try to show people is this is the impact of the language you'll use on your customers, your readers, your clients. In a sense, complexity itself is really creating exclusion. So if you are using terminology that people can't understand, you're automatically excluding them from the conversation. You're excluding them from accessing goods, services, your own services, because they don't know how to speak to you or they don't know the benefits of what you're providing. So what we try to do with making something more accessible in its nature is making it is bringing in more inclusion. So we're creating these we're breaking down these barriers that the complexity is creating. So by making something accessible, easy to understand, then we are increasing other people's ability to be included in that conversation. So really, accessible language is about considering people's different abilities and then communicating in a way that more people can understand. So one person mentioned there that in law, we generally copy and paste. And that's, it was okay. We care more about people and their abilities and their needs now. It really requires a lot of effort in the beginning to think about your audience, to think about who am I talking to and will they be able to understand this? So really, it's not rocket science, but why does it continue? And I think that in a lot of disciplines, a lot of sectors and careers, that there are things that we just continually do. We copy and paste from the past. It's a traditional way of doing things. But luckily, the mindset is shifting now, and people are trying to, be more accessible and consider who they're talking to a lot more, design for them. One of the things that I see and I think happens a lot is that we have this ideology or we have this assumption that because I know something very well, they will too. Because I understand what this information is saying, they will too. And what we're really doing there is we're bringing in our own ability bias. And especially, I'll just speak in my experience. I live in an English speaking country and English is my first language. So when people write legal documents in English in their first language, they make the assumption that everybody else is going to understand that. And that's simply not true when societies are so diverse, different levels of education, different levels of English, and just not knowing what these terminology mean in a legal context. So there's a lot of bias that we bring in on our own behalf that I think continues that traditional way of doing things. Why should you care about it? Well, um, I'm not sure what type of companies a lot of you might be working in, but if you're in the tech sector, if you're in gaming, or you're in client services, people are always asking themselves questions. Parents are asking, should I let my kid play this game? We're all asking, should I add my personal information to this app? Should I add my photos? And also everyone is, how do I know what I'm signing? What am I signing away? Whether you're setting up a company and you want IP protection, you're signing a contract for a new job, or you're getting into a mortgage, people don't always know what they're signing. And a lack of questioning doesn't mean understanding. A lack of questioning can mean often that they don't know how to form the questions because they might feel stupid. And again, that is excluding them from it. And this is something that can get people into trouble because they don't actually know what they signed in the beginning. From a from a business perspective and being lawyers, if people can't understand you, they can't trust you. And it just so happened, this was a coincidence. At the weekend, I did watch Erin Brockovich. And some of you might be rolling your eyes. Maybe it's not a complete representation of the law, but I thought it was a good example of a situation where there were two people maybe, trying to speak to people in a community that were vulnerable. And the only person that was able to get 634 people to sign, plaintiffs to sign, was by really speaking to them at their level, getting in front of them, having empathy for their audience, thinking about how to speak to them, how they will understand. And if you haven't seen the movie, the other lawyer is probably the stereotypical example of the legal jargon and all this, but it is an example of using the language to build trust. And trust is really central to getting people to buy from you, but getting people to trust in you. And when you have their trust, you have their loyalty as well. From a business perspective, again, is that loyal customers stay with you longer, they're more willing to buy, they are less price sensitive, they're going to spend more money with you. So really developing that trust from the beginning, from the way you speak to people, is really, a crucial element, and could perhaps be something that is your advantage as a lawyer, as a consultant, or as a company. Another reason for it is that governments are now starting to take notice that it is mandatory, it's going to become mandatory, that terms of service, terms and conditions, all of these things, it will be written into law. It started in America that the way you describe this information should be readable. And so it should be understandable and accessible to, people from all different ages, all different backgrounds and abilities. So let's look at it in action. So Call of Duty might be something that some of you know. It might be something that some of you play. I just looked today at their privacy policy and I put it through our system. Call of Duty, I think people that use this really range in ages. I'm pretty sure there's 12 and 13-year-olds up to adults that are using Call of Duty, even though people at a younger age are probably not supposed to. So I took the privacy policy and I put it through our software system. And what we find, what we do with this is we try to categorize all of the words and all of the language to see how would this impact the reader. So what we find in this is that it expects readers to have a university level of English. So when you see difficulty rating here of 6 out of 6, that's the highest in our algorithm. And that means that that's using English at a level that is like expecting you to have a PhD from university. It's the same level as academic research papers. It expects you to be a fluent English speaker. This is in English. And so here the English level is that it expects you to have proficiency, fluency in English, and then also be able to understand legal jargon. We can see here that there's what we call the processing level. And the processing level is that brain power. How much brain power do people have to put in to understand what you're talking about? And here it is quite high. And that's a combination of not only the words and phrases, but also the grammatical structures that are in there as well. There are other things that I didn't show here, but the readability level is low. Readability might be something that some of you are familiar with. That counts the number of words and sentences and the number of syllables. It is one good metric to look at, but there's a lot of other things within language beyond readability that can show what impact that's going to have on people. So what we do is we look at every single word based on the English level, English language. So here on the right, you can see A1 to C2. And this is for any of you who have gone through learning English as a second language, you'll be familiar. A1 is when you're at a beginner level. C2 is when you're at a proficient or more fluent level of English. And other is what we categorize as maybe potential jargon. So what you can see here is that on this scale, we have quite a high percentage of words that are above a B1 level. So B1 would be intermediate, B2 is upper intermediate. And so we have a lot of words in there that are at this high level of the scale. And that means that if you have people with low literacy, poor education levels, or an intermediate level of English, all of the words and phrases above this level, they're not going to understand. And when people typically don't understand something, they ignore it. So they could be signing, agreeing to things that they don't understand, and actually, they don't fully understand it. You can also just see under that there that the number of difficult sentences, there's 159 difficult sentences within this. And that doesn't mean that there's errors in them. It means that the amount of brain power people have to put in to understand those words is high. And so if you use Grammarly or something like that, Grammarly will look at errors. What we look at is impact on readers and their, cognitive load. What we try to do is to show that if you have certain words, do you always need to use that particular word? So we classify words based on a scale of commonly used or easy to understand to difficult to understand. Sometimes we use a word at the difficult end of the scale. And just as an example, my mother is currently filling out her pension application form, and she made a mistake. And she got an email to say that if you have made a mistake, if there's an error in your application, please amend your application. She ignored it, left it, said to me months later, well, I don't know what happened because now, they just sent me an email saying, please amend it. And I said, yeah, well, why didn't you? She's like, well, I don't know what amend means. So my mom is an educated person, but English is her first language, but she didn't know that word amend. And the question I would have there is, why use amend when you can use change? Change is a word that is commonly used. So when we use more commonly used words to say the same thing, people aren't going to make mistakes, and they're not going to lose out on their pension, and they're not going to lose out on money or services because they didn't understand one single word. And so here is just an example of the difficult sentences in this. So we have like long sentences or words with more than 20 words, very long words, sentences with more than 30 words. And then looking at particular phrases or sentence types that will again add this cognitive load, this processing effort to people. So what can you do? You don't always need to have technology to help you. You can simply just investigate yourself. So things that you could ask: how long are the sentences? It is okay to have long sentences. It is okay to have some sentences with more than 20 words when you have a balance. So it's not that everything needs to be very simple. It's not that every single thing needs to be, less than 10 words, really basic language. There can be a balance depending on your audience. If you're writing something for a legal audience, of course, you might be, you might be able to use more legal jargon. But if you are writing for a general audience, especially if it's the public and you don't know their ability, then you should assume that you need to be at the lower end of the scale and thinking about the words that you're using. So you can just investigate documents you have now. How long are the sentences? How many long words are you using? So when you're using words that have 3 or more syllables and there's lots of them in a sentence, it makes it more difficult again to process. Are all of these words necessary? And words that I find that perhaps are not so necessary and could be changed, I don't know if you agree or not, are, therefore, herein, now, now, there, herein, whereas, all of these extra words that perhaps could just be changed to this means that from today onwards. So looking at these extra words, that are they so necessary to the true meaning of what you're trying to get across? So just asking yourself these questions could just even help you simplify it. And really what you would do is question, is this how I would speak to a child or to a grandmother or to my grandmother? And the key here is how we speak. How we speak and how we write are very, very different. So we don't say, the information herein contains, you don't say that in conversational language, whatever language you speak. So especially in English, we tend to create more academic words around things that we're writing, you know. So if you're not going to explain something to somebody using the exact same words, well, then these words shouldn't also be in, you know, the documents as well, because you can assume, you know, they could be at the higher end of the scale, and it means that people are not going to understand them. And when people don't understand, they're not going to take action, and they're probably not going to know that your service you're providing is of benefit. And on the worst case is it could get people into trouble, which is what we want to avoid. So that's, you know, what all I have to say on the accessibility from the language point, and we can go through more Q&A. And so what I will be doing as well is kind of building on this conversation about accessibility from language, the language perspective, but also other digital things, and that includes information design that the guys here at Legal Design School are also doing. So I'm going to be creating a community group based on this. We'll have more events and talks and things. So if you're interested, I'll share a sign-up link at the end. And then also, if your firm or consultancy or company that you're with, you know, we also help to do kind of accessibility audits. We can look at websites or documents. You can use our software as well. And for participants of the Legal Design School, then we can offer a discount of 30% off as well. So I'll share a link afterwards, and I'm happy to answer more questions. So that's everything from me.
Thank you so much, Niamh, for the presentation. I really like the hands-on tips and tricks you shared with us. And next, if you have any questions for Niamh about how to design your legal documents, the language, please go on.
Maybe I spoke a bit quickly as well there, so I'm happy to go through anything that maybe wasn't clear, or, you know, explain things a little bit more. So
yeah, there's already first one in the chat. Can you, Miroslav, put on your camera and microphone maybe to share the question, or do you want me to read it? Yes, there you are.
Sure. I'm sorry. Hi everyone. Thank you very much for the presentation. I had a hard time of actually formulating my question. Actually, my question is, so I live and work in Luxembourg, and we have already too many official languages, French, German, Luxembourgish, but a lot of people also speak German, and a lot of Italian, Portuguese, Spanish people. So it's very diverse. And so for us, actually the working language would be English. And so sometimes when I read phrases, they sound like literal translations from mostly Roman languages, French or Spanish. And so I feel that these phrases actually help us a lot to be understood, but sometimes they are not grammatically super correct. So what do you think about that?
So you're saying that the phrases do help in a working environment?
Yes, because I feel that people just understand them because in those kind of languages, you would use this expression. And even if it's not the correct English expression, it still works. And so my question is, can we accept to speak bad English only because it helps us to be understood better?
Yeah,
I was wondering.
But are you being understood better by your colleagues? Is it by colleagues or by clients?
Yeah, I think both. Also, our clients are also people from everywhere. So rarely native speakers.
I think it goes back to, what is the purpose of communication? You know, what are you trying to achieve with your conversation, with your communication? So like when I taught English for years, if people said something that was grammatically incorrect, I wouldn't stop them. I let the flow of the ideas continue. Because if you're going to focus on this grammatical thing all the time, you're blocking creativity. you're blocking the ideas, you're blocking networking connections and things like that. And I would favor idea sharing before I would favor grammar. And that's, you know, people might not agree with me in that case, because the problem can come down to is if the grammar or the vocabulary isn't correct and you're on different wavelengths. So there is a danger that you think you're communicating about the same thing, you're on the same page, but actually you're not. So in a sense, is it okay to use the phrases that are not grammatically correct so that we can engage and share ideas and achieve a purpose? Then yes, I think so, of course. I would then, if it's from a client side, I would make sure with somebody fluent in that language that you're using a phrase or something in a correct way, because you know, there's so much meaning between the words, and you don't want to be on a different page to them, because again, you could think you're agreeing on something, they could be signing something they think that you're aligned with. So in terms of like conversation, fine, go with it, share the ideas, but in legal documents, I would make sure that it's checked, so that it's, you know, what you're trying to communicate is getting across in the easiest way, and there's no room for contradiction, or there's no room for questioning what do you mean by that, you know. And when we use metaphors, slang, things, especially metaphors and things like that, there is an extra question, is what do you mean by that, you know. And if you can erase that, especially if it has to be a signed thing, then I think you're covering your basis, and it just means that everybody's going to be on the same page quicker.
Sure. Okay, great. Yeah, because I was watching a video on YouTube that explained that English language is evolving super quickly because a lot of non-native people are speaking it, and they're actually changing how things are said, and this is very weird because it doesn't happen in a human life to have that much change in one language.
Yeah, I would say like phrases, metaphors, anything like that, definitely keep out of legal things. So anything that where there could be, you're leaving yourself open to be questioned about something, and what you mean by something is not going to be great, I would say.
Great, thank you. As a good lawyer would say, duly noted.
Yeah.
Yeah,
thanks again.
Yeah, absolutely. One of the most important things is to have a feedback round after you're drafting. So it's all about the audience who you're drafting to. And also, if you're working in an organization who are already using the design guidelines, and you have your brand book and you have your communication experts in-house, so it's all about knowing how to use these tools that are already there. So for example, you work in a big organization, you have a beautiful brand book of tone of voice guidelines and what words not to use, and is it an active or passive language? And that's something that we have noticed in our project, that it's always lacking, even though you already have the teams and you have the tools and you basically have the guidelines that you can follow when you draft your legal document. For some reason, because law is law, I think for some reason they're not being used. So most of our time we are like educating lawyers how to make advantage of their own tools in-house. So, and that's something we also cover in legal design school. But consider, I know that there might be students here today or lawyers from a smaller organization that doesn't have a design guideline, but that's something that you can start to work on as well, building your own design guidelines for legal documents as well. And then you have the common guidelines for the whole team. And that's basically a rule book that you can check every now and then, like what kind of language am I using? I don't know if this is a thing for Niamh. I don't know if you have worked with these kind of situations that there's a brand book that can be followed, but clearly you can see from legal document that it's not happening at the moment.
a lot of organizations will probably have the brand guidebook for people to follow, but again, they're using, okay, it might be in terms of tone and things, but in terms of the actual terminology of words, there is another idea, especially in law, that you have to use these words. You know, if I leave this word out of this contract, it's not going to be as legally binding or something like that. And of course, there's going to be instances where that's necessary. What I would say in that case is that, you know, try to look at the contracts again, the documents with a different perspective. It's like, how can we also explain this to somebody that, you know, is a child, let's say, you know, make the assumption that people can't understand you. So yes, you're going to need the specific words, but beside that, around it, you can explain it, you know, more fully. And so what you're doing is you're covering both sides. If somebody is reading something and they already understand the words that are in that, if you give an additional explanation of that word in brackets beside it, their eyes will skip over it and it won't stop them from understanding. But what it will do is it will put an extra layer of kind of protection or whatever for the person who doesn't understand it. So sometimes the words and the explanation can go side by side without it becoming too much of a burden, especially for the one that will know it, but it will add that extra level of understanding for people who are not so familiar with you know, with words. Even they're saying like duly noted, people will be like noted, you know, or everybody won't know what duly means, you know. So it's like, okay, and we don't ask questions when we don't know what things mean because we don't want to feel silly. You know.
Great examples, Niamh. I have to say that my heart skipped a beat because my 15-year-old kid plays Call of Duty too, and you know, he's probably playing it at the moment too. And even his level of English is really good. I don't expect that he would read the terms of service anyway, right?
Mm.
But the terms said, and this is a funny thing. The terms state that if you are age 13 but under 18 years of age, you and your parent or guardian must review the terms and the privacy policy together. So now I'm forced to go through these terms too with my kid, and you know, it's especially for a 15-year-old kid, it's just terribly difficult. I mean, it's for a trained lawyer that's really difficult to go through these terms. I mean, it's like 12 pages long, at least, if I would print that one out. So let's say that seriously, I would print these terms out and go through them with my kid who is actually playing Call of Duty. How would you tackle this problem? Like, what kind of information can you communicate to a 15-year-old kid? How would you approach this problem? How could we draft something that even like 15-year-old could read together with his parents that are lawyers?
Yeah. Well, that's the thing. I think firstly, the responsibility is actually on the company. So the company saying, you and your parents must sit down and figure this out, is, you know, I think they're shifting the responsibility away from themselves. I would also say that not every, you know, 15-year-old would have a father as kind of, you know, willing to support and able. You know, how many kids are playing this and their parents don't know they're playing it, or their parents themselves don't have a good education level. So again, that responsibility, putting it on the user, is, you know, I think you're shifting the blame. It also means that you have to, again, understand everything that they're talking about, and you have to shift that complexity to simplicity. And a 12-page document, that's a lot. All the child or all anybody really needs to know is, if something goes wrong, what happens? Are you going to take my information? If I leave this game, or this company closes down, what do you do with my information? Am I going to get in trouble? You know, like it doesn't have to be a 12 page document. But I think that's all you're looking for is, what are my, you know, how am I protected and how am I not protected if something goes wrong? And it might just be 5 bullet points, you know, especially for a 15-year-old. I question why there needs to be 12 pages, and that's to protect themselves, you know, and we kind of see that in a lot of cases in legal, and there's a lot coming out about like data privacy. You know, they're burying people in all of these books and burying all of this language, burying people in all the pages, putting the responsibility on us to understand what they mean, you know, and that's not fair, really. And so in a case, not with Call of Duty, because if you're a gamer and you're, you know, obsessed with that game, these type of things are not going to impact you. But if you are maybe older, Facebook, Instagram, WhatsApp, if something comes out that there's something in the privacy, there's something that they could do with your data, they're going to lose their customers. You know, people with an older age, maybe, you know, we will kind of say, well, I can't really trust them anymore. As soon as you lose your trust in an organization, you're going to move away from it. You know, but I think the responsibility is on them. Unfortunately, they shifted to us.
Have you or anyone from the attendees follow the TikTok case that it's going on at the moment, that they can follow your keystrokes when you have downloaded the application? So that's one of those examples when you really lose a trust. For example, I don't have a TikTok, so that's a good.
Me neither.
Have anyone here, lawyers who are following the case, what's happening there? Have you read through the terms of service? Because I know Joe Rogan, the famous podcaster, did, and the shitstorm started from there. So I think that's a really good case to see that how they are now, or are they redesigning their terms of service, or how they come up with explanations why they are doing that, or why they have like buried down the information. Like it's not only about, like we have talked today, it's not only about making the legal documents plain English, but it's also how you present them to clients. So if you're using dark patterns, for example, nudging the customers to click accept without reading, so there's no point of basically redesigning the text, or that's just like a greenwashing, so to speak. So have you, Niamh, or anyone here, have you followed the TikTok case? Because I think that's a huge.
I personally, I'm not so familiar with what's happened with TikTok, and same, I don't have a TikTok account.
Yeah,
I followed it very closely. It's super interesting. You should definitely, at least the lawyers should be very, very interested in this one. This is a very, very juicy case.
Mm-hmm. But I think, I don't know if they're going to change anything, or I think when companies, they will get to a point when it is going to hurt their user numbers, or when it's enforceable. You know, it's because they're such a behemoth, they can, you know, in a sense, do whatever maybe they like, and the age range of their users as well. You know, younger people are given a lot more information away, and they don't really think it's a bad thing. I think maybe it's older users that might be a little bit more concerned because we haven't grown up with it in the same way. But I think unless there's something enforceable or an impact on their user base, their numbers, you know, I wouldn't say that a lot of companies will change.
And then,
Niamh, you started with a great question. So if everybody has to abide the law, so why doesn't everyone understand it? And I know that's a wicked problem, and there are probably no like easy solutions for that one either. But I have to ask, like, what do you think are the kind of like the low-hanging fruits for lawyers or for legal professionals? What are like the top 2 or 3 things that we could do immediately? What is that we need to stop doing?
I think the immediate thing is take a step back from your lawyer, you know, take your lawyer hat off and look at a document, a contract, and just, you know, ask, if somebody asked me to explain what this document is talking about, how would I explain that? If there's a, you know, think of, you could record yourself, whatever, or just imagine you explaining it to your 15-year-old. When you hear the words or the way that you would explain it in real life, you know, out loud, and you look back and you haven't used any of those words, you're seeing kind of like a gap there between how we actually use words, you know. So conversational language, we use a much more informal tone. We use more commonly used words every single day. The words in a document are not commonly used. So even just looking at them, do I use these words every day talking to people? Probably not. Is there another form of a word I can use for this? And the example is like amend and change. I don't need to use amend. Change is the exact same, you know, meaning. There are things perhaps that in a legal context, they don't have an easy way to just explain it in one word, and that's okay. Use 3 words, use 4 words, because the point is getting the message across, not just replacing one word for another. So it's really about kind of thinking, would I use these words in a conversation? Can I change these words for an easier explanation? That's, I think, what everybody can do kind of initially, by just taking your lawyer hat off for a moment and looking with fresh eyes at a document, at a contract.
I also added one company to follow, Revolut. I don't know if you're familiar with the company, but what they're doing with the terms and when they do any updates, because I'm their client. When I was doing my exchange here in Taiwan, I found their product really good because my costs were really low using Revolut. But like after that, like I have noticed, because I'm still a client, and they always update me really clearly when they do any updates to their terms and where they find the new information. And this just pops out from other big companies, how they communicate their legal documents and when they do these kind of updates. So that's already something that you can start today with your company when you do the updates, already using bullet points and plain English to communicate it. It makes me feel like I understand it, and also I feel important. I'm their client, and they really want me to know what's happening within their like legal field.
Yeah, and I'll just say on that, I see the from the Revolut link. What they're also doing in this is they're using the word we quite a lot. We have made some clarifications. We've done this. We have done this for you. And another thing that legal documents don't tend to do is use kind of the first person pronouns. You know, it might be the service provider does this, the client does this, and that can be hard to follow, again, going down. So when you're using pronouns like this, you're increasing the engagement factor as well. So if you have a long text, and if you have something that requires, you know, a long bit of reading, by saying we have done this, so you can do that, just that simple method is making it more engaging, and it means then that you're going to, the chance of sustaining people's interest and getting them to read it is higher. I recently just so working with like financial institutes, with banks, and my own contract for them, you know, I wanted to move a little bit away. You know, they've hired us for plain language. They're trying to move to this plain language place, and my contracts are in plain language where possible. You know, and when it went to their legal in-house team, they removed all of that and they put all the legal jargon back in. Now the bank are hiring us, you know, to do this. And so then there's kind of a you know, not everybody is on board with that. And the meaning was still the same because it was accepted by the managers, the directors, it's accepted by all of those. But then there's this idea that it just needs to be the service provider versus the client, rather than we, as the service provider, will provide you. And you're just making that level of personalization and engagement, and it just makes it easier for people to digest, comprehend what you're actually saying.
Thank you, Niamh. We have a couple of questions from the audience. First, Claudio, you have your hand raised up, so just put on your mic and the camera. Yes, nice to see you.
Right here. Thank you.
Hello.
Thank you very much, all. Good morning from Brazil. Thanks for the wonderful insights. I'd like to just agree with Lavanya that you have perhaps found the perfect question to open this discussion. I've been working with companies, law firms, and also public institutions here back in Brazil along the past 2 years, and it's an interesting movement we have here. We have federal law demanding that plain language be used in contact with citizens. And there are courts. I've been working with courts that had already adopted plain language and also a visual transformation of their legal documents and the formal decision. So I think it's an interesting move. The question is, I'd like to ask you two quick questions. One about resistance. What level of resistance do you face if you're perhaps hired by a company that level of resistance is not very much felt? You are already backed up by the C-level of the institution. But in the public sector, there is clearly not a very, let's say, wide adherence to these new standards. It's difficult to change things in the public sector, and very relevant because it's a segment of the institutions that is in direct contact with the citizen. And second, how long do you think we're going to offer this to lawyers as an add-on? Because if we keep this mindset, we're trained to use that language over decades, over universities. I'm Brazilian, but I've worked in Belgium, I've worked in the US, and I've worked in Portugal. We're trained to do that. It's not a flaw, it's a feature of the legal profession. So how long do you think we should be offering this as an add-on, as a course, as an add-on ability to lawyers that are already on the market, and try to maybe shift this into universities to form different lawyers? Thank you again very much.
Thanks. And I think that the two questions kind of feed into each other as well, because one, resistance is high. And what I think is where I find resistance most, again, speaking, within English language, or it can be within any language, when somebody is working in their own language and they've maybe always lived in that country and they've never been in a situation where they've had to travel abroad, or they've had to work with, be in a situation where they're not fully understood or they can't fully understand, it's harder for them to comprehend why this is needed. And I have had managers of again, corporates, financial institutes that will say, everybody understands everything we say, because they come from their own ability bias, because they see people nodding their heads and they don't see people asking questions. And to them, that means everybody understands everything clearly. So when you have such a strong bias towards that, resistance is high. I think that it is only recently that the idea of plain language and accessibility and inclusion are very much more at the forefront. So it's really about raising awareness and education. And I think that's the only thing that is going to break down resistance. For people that are truly resistant, the only thing that is going to break that down is legislation. When it's something that they have to, do for compliance, then they'll say, okay. And so the resistance as well moves into, I think, the entire sector, the university level. I started out in university and doing language and selling software and things to university. They are highly resistant. So what I think is, for the next number of years anyway, it's going to be the individuals that are probably adding on to their courses or adding on to their own level of education in order to bring it in. So I would say, from a university perspective, training, it's something that is going to be maintained, because that's the way your books are. That's the way the courses are. It's going to be maintained for a long time until the majority, the shift for compliance, for the companies, all of that becomes like, actually, there's a better way or a different way to do these things. But I'd say it'll be an add-on for a long time.
Yeah, I want to say something here as well, because I think personally for me that the first 2 years in law school, one of the most prominent law schools in Finland, Helsinki University, the first 2 years was basically learning how to get rid of to talking like person to person, you know? Like first I'm trying to get rid of like how should I speak as a lawyer for the first 2 years. And I'm like the first year I didn't even understand what I'm reading basically, because in Finland you get into the law school by reading books and trying to remember everything for 1 month only. So I don't know the subject actually. I'm just learning how to remember things. And the first couple of years, we're learning how to speak as a lawyers. So from my experience, we should have the first course on information design and these things already in the first year. That's truly where the change begin, because we had our first university course this spring, and that was for students who are on their 4th or 5th year. And that's already basically too late because they have implemented everything from the first 3 years. And it's really hard to change how you approach the legal documents and the legal work in general. So that was, Claudia, really good question. Thank you for that. And we also have Vanya raised her hand, so please. We still have 5 more minutes.
Hi again. That was a great talk, guys. So just to connect to the information design part, so I'm just quickly going to narrate the experience that I've had. So I had a client who walked in, and they probably had given a certain amount of money to another person. They're unable to recover. So they had come to me to draft a legal notice. So what I had done is I had to kind of, I used the concept of information design. I just laid out everything right from 2002 to now, and what is the installments, number of, the amount that was given, the rate of interest, etc. Now that kind of shook him, saying that, is this as serious as it was before? Meaning when I started using information design or adding a bit of table or colors for more clarity, he kind of thought it's not a serious document anymore. And how do you balance the, the easy quality that we're trying to drill into client's mind, and we're trying to say that it's user-centered and it's designed for you to understand better, versus the seriousness of a legal document?
I don't know if you want to take that, Aku, but
yeah.
But I think it's, again, our mindset. We just assume legal documents have to be black and white, boring, and hard to understand. Yeah,
I just like to say that it's a really rocky road, because we are just at the beginning to like presenting these kind of documents to clients or to the end users. So we shouldn't be afraid, like even though the clients would approach the documents like, oh, what is this? Can I trust this because this looks too good? That's a ridiculous thought. I think in my head I have also had the same thought, that is it too clear or something, because the clients are saying that like, where's the, how do you say it, koira haudattuna, Antti, the saying in Finnish, that there's something like hidden in the document because it's too clear. So yeah, that's just how it goes for the first 2-3 years, or maybe 10 years even. But it's always a balancing act.
Yeah.
No, if something to add.
So I was going to add on to that and let you speak now, Antti. Another way to combat that is with this person or with their company, if they have experience of sending out contracts or something that they know, for example, a negotiation, I send out a proposal, or negotiations can take months. We typically have 5 meetings before we get to it. If there can be some measurable way to see that the outcome of this simpler document has changed something, for example, the person has paid up quicker, we had less questions, we had less meetings. Now you can show that there's a measurable outcome to it. And I know that an organization, they made their terms and conditions of a marketplace easier, like with plain language, and they only had one. They were signing up 30 companies, and they only had one person ring with a question. And in the past, they would have had to answer questions from all of them. They're, answering calls. So the amount of time they spent on a negotiation was severely reduced because of the simplicity of it as well. So trying to connect it to a measurable outcome could probably help people see that there is benefits in it.
Great points, and if I may add to that one, it's not really surprising that these old documents stick so much, right? They're like symbolic for seriousness and legality, and the document it just feels like a legal document to you, and there's a good reason for it, that one also. But also, I think one part of the problem is that legal documents rarely get tested with actual users. I think that's one of the, we could easily borrow techniques from the playbooks of UX designers or service designers and actually test the documents with real users and get that kind of measurable data also, how people really perceive these documents. And then you could say quite objectively that this document works better than the old version. So we have a good reason to use this document, and it's not just you as a designer who feels like this might be better than, that's the whole point of legal designer, of us making assumptions and then testing it out with real actual clients and then iterating based on that one. Or we can use technology like Niamh showed us to test the end products. But I think that's the key, making good valid assumptions and then testing it out, and then based on that feedback, doing a new version, always striving for better versions. Great questions, and very, very good answers also.
Thank you. That was great responses from you guys.
Okay, I think we are running out of time. It's 3 p.m. here in Helsinki, Finland. At least it was a morning in Brazil. That shows that we have people all around the globe who have joined us for the first Legal Design School event by Niamh. We will get to you after the show for information about Niamh and her company, and also Legal Design School. We will have these kind of events in the future as well, and they will always be free. So please join us in the future as well. And it was my pleasure to have you, Niamh. Thank you so much. And for all of who attended this event, it was nice to meet you all.
Thanks everyone, and I just put my email address there in the chat, so if anyone has additional questions, do reach out. I'll be happy to answer.
Yeah.
Great event. Thank you so much. Like Niamh said, we have to be able to take a step back sometimes, take off the lawyer hat, really think about the language that we are using so we can make law a little bit more accessible and a little bit more fun. And now I know what I'm going to do this evening, analyzing terms of service of Call of Duty together with arbitration clauses and waivers and whatnot. That's a great activity for today.
Yes, and Dora, is there a replay available? I will upload it to YouTube, let's say tomorrow, and you can find it from there, and we will send you an email update about that one. All right.
Thanks, everyone.
That's
excellent.
all.
Thank you so much. Thank you.
Bye.
Thank you very much. See you. Have a nice afternoon.